Thank you everyone for joining us. It's great to see so many attendees. For anyone who's new to the VWV In-House Lawyers Club, it's probably just worth explaining the background a little bit. Originally, back in pre-COVID days, the idea behind it was to have some in-person webinars where it was not only an opportunity for VWV to speak to you, but also for you to speak amongst yourselves and sort of chat about issues that you're facing. Obviously, coronavirus has put paid to that, and we're now doing things online with these webinars. The great thing about that is we're not tied geographically anymore, so being able to reach a lot more people. So this is definitely something that will be continuing in the future. The challenge for us at the moment is just trying to figure out how we can bring back in that element of the in-house lawyers being able to talk to each other. We're giving some thought to that, and we'll probably share some ideas in the new year. But for the moment, what we will be doing is sort of continuing with these webinars every couple of months. If there's any sort of areas or topics that you'd like to cover, then please do get in contact, and we can look at including those in future webinars. So that's the background. A bit of housekeeping. This is a presentation rather than sort of a Zoom meeting, so there's no need to mute microphones because we won't be able to hear you anyway. On an admin point of view, if there are any issues, then there is the chat function, which Imi will be keeping an eye on, so she'll be able to sort out any problems you may have. If you've got any questions in relation to the talk, then we also have the Q&A box. And if you'd like to put those questions in there, then I'll be monitoring that with the idea that I can then put the questions to Claire at the end of the talk. One thing I should point out is that this webinar is being recorded. So if you do put questions in there, I would recommend avoiding them being too specific or identifiable in case they are included as part of the recording. And preempting one of the invariable questions, yes, we will be sharing the slides after the event, and also you'll be able to access a recording of the webinar once it's been edited afterwards as well. So that's housekeeping out of the way. In relation to the introduction itself, you, like me, you may not have given a thought about data protection since May 2018, when you were probably inundated with emails either telling you that you're about to go to prison for failing to comply with GDPR, or otherwise pleading with you to remain on mailing lists that you didn't know you were on in the first place. If, like me, that was your last dealing with it, then I've got good news. Today we are joined by Claire Hall, a senior associate in our data protection team, who is going to guide us through the new and not so new aspects of data protection in the post-Brexit world. So, Claire, over to you.
Brilliant. Thank you very much, Nick. Good afternoon, everybody. Thank you for joining us. So today's presentation is on data protection and Brexit, and really kind of the main things that you need to be thinking about. And also we'll finish off with some predictions for 2021 as well. Okay, so 5 main areas to think about today. So the data protection regime after the end of the transition period, international data transfers, data flows, Schrems II, which was a case that was decided over the summer, and the follow-up guidelines from the European Data Protection Board. And then we'll finish off by thinking about the latest from the Information Commissioner's Office, and also kind of crystal ball gazing a little bit into 2021, what might be on the horizon for data protection specialists and in-house lawyers. Brilliant. So the new data protection regime. So as Nick alluded to, the General Data Protection Regulation came in May 2018. And the GDPR is a European regulation, which means it applies to all of the European Economic Area. And so not just the EU, it actually applies to Norway, Iceland and Liechtenstein as well, so comprising the EEA. So throughout the presentation today, I'll probably reference the EEA more than I do the EU for that reason, just in case you're wondering. So the GDPR obviously applied since May 2018 and is supplemented, in the UK at least, by the Data Protection Act 2018. So data protection specialists have to consider at the moment both the GDPR and the Data Protection Act 2018. The Data Protection Act 2018 contains the aspects of data protection law which are UK specific. So for example, if you are dealing with a subject access request, the right itself is contained in the GDPR, but a lot of the exemptions are actually contained in the Data Protection Act 2018, and those are UK specific things at the moment. So that's where we are at the moment. So at the moment, you've got those two pieces of legislation. There's been no change to this during the transition period. So it's been business as usual pretty much this year, but obviously we're now, couple of weeks away from the end of the transition period. So we need to start thinking about what's next. So post-transition period, so this will be the 1st of January 2021. The GDPR will stay part of UK law, but it will become the UK GDPR. So going forward, we'll have both the EU GDPR and the UK GDPR. They will basically be the same for all intents and purposes. And that's a really important message, I think, for my presentation today, that actually the vast majority of things will stay the same. However, there will be some tweaks made to the GDPR to make it into the UK GDPR. So specific things which are UK, to make it work in a UK only context, essentially. There'll also be minor amendments to the Data Protection Act 2018 and also the Privacy and Electronic Communication Regulations as well. Again, these are where you've got things like references to European Union law, they'll then be replaced by references to UK law, that kind of thing. So just to make everything work seamlessly together. But like I said, for all intents and purposes, very similar. Now, one thing we do need to think about is the fact that the EU GDPR has what's called extraterritorial scope, which means it sometimes applies to organisations outside of the EU, outside of the EEA. The first, I've got 3 situations on this slide here for when the EU GDPR might still apply to some of your processing activities. The first one is only if the UK doesn't get an adequacy decision. So you may have heard lots of people talking at the moment about whether the UK will get an adequacy decision or not. We don't know at the moment. Last time I checked, which was about half an hour ago, we didn't have one, but it might change in the next few weeks. But if we don't get one, then organisations in the UK must continue to comply with the EU GDPR as it is frozen in time on the very last day of the transition period in relation to personal data of individuals outside the UK that were collected before the end of the transition period. So this is quite an interesting concept to get our heads around. But as I said, this only applies if we don't get an adequate decision. The second scenario where some of your processing might be caught by the EU GDPR is if you offer goods and services or monitor individuals in the EEA. This is commonly known as the targeting criterion. But just to clarify, this will only relate to the EU GDPR will only relate to the relevant processing here. Now, it's called the targeting criterion because it only applies if you're actually targeting individuals in the EEA with the offer of goods and services. So if you're making your offer of services to the world at large and people who are in the EEA happen to be taking you up on your offer, that's not enough. It has to be very targeted towards individuals in the EEA. The final one is relating to having an establishment in the EEA. So this is where you process personal data in the context of activities of an establishment in the EEA. So for example, if you have a branch office, for example, in France, and the activities of that office, you're processing personal data in the context of the activities of that office, the EU GDPR will continue to apply to that relevant processing. But for everything else, it'll still be the UK GDPR. But these are just some things to really think about. So I would recommend having a think about whether this will affect you going forward at the end of the transition period. So maybe coming back to, we were talking a moment ago about how GDPR came in 2018. In 2018, you should have been doing things called data maps. So working out what data you held, whose personal data you were holding. That's actually going to be quite a useful thing now, because this should actually help you in this transition period here, because without knowing what personal data you hold, it's very difficult to work out which law you'll need to comply with. But I do want to reassure you that in practice, the UK GDPR and the EU GDPR are going to be virtually identical. So actually the change is not hugely significant, at least in the short term. In the long term, we may see the two laws start to diverge slightly, particularly around the courts making opinions or making judgments, in the UK as well. So the two laws might diverge in the long term, but in the short term, hopefully this won't have too much of a practical impact because you're already complying with the GDPR, aren't you? So hopefully you won't have too much of an impact. Okay, EU representative. So if you are caught by the second of the things on that previous slide, you need to appoint a representative in the EU in certain circumstances. However, there are 3 exceptions to this requirement to appoint an EU representative. The first is if you have an establishment, for example, an office in the EU already. You don't need to worry about appointing a representative. The second is if you're a public authority, and I know we have lots of you attending today from public authorities. So public authorities, just as a reminder, under data protection law, public authority is defined as an organisation that's caught by the Freedom of Information Act. So if you're caught by the Freedom of Information Act, you don't need to worry about this EU representative point. And then the third is really an exemption or caveat to the requirement to appoint an EU representative. If the processing that you're doing that is caught by the targeting criterion is only occasional and not special category data, so not health data, for example, or political opinions or ethnicity data, that kind of thing, and not criminal offence data, and it's unlikely to result in a risk to individuals, that means you don't need to appoint an EU representative either. If you do need to appoint an EU representative, it must be based in one of the EU or EEA states where the data subjects affected are located, and they should be authorised to act on your behalf in relation to data subjects, for example. The EU representative's details should be included on your privacy notice, which is provided to data subjects in the EU and also made accessible to supervisory authorities. So, for example, you could put the details of the EU representative on your website. When the GDPR came in, you may have heard about something called the one-stop shop. So the idea behind the one-stop shop is if personal data is being processed across borders, so cross-border processing it's referred to. So you've got data subjects maybe affected by a data breach in multiple member states. Then the one-stop shop means that one supervisory authority, supervisory authority is the data protection term given to regulators essentially. So the Information Commissioner's Office in the UK is the supervisory authority. One supervisory authority can lead on the investigation of this cross-border processing. Otherwise, you can end up with a situation where you are investigated by multiple regulators at a time. So it's just a one-stop shop. Now, this might be an issue for you now if you have an establishment in the EEA and the UK, and at the moment, the ICO is your lead supervisory authority. Because the ICO at the end of the transition period will no longer be able to act as a lead supervisory authority. So you'll need to appoint a new supervisory authority in the EEA. If you only have one establishment in the EEA, then it's quite easy to work out who your supervisory authority is going to be. If you have 2 establishments in the EEA, then you'll need to give some thought to which of those 2 will be your new lead supervisory authority. Okay, I know we have quite a lot of data protection officers attending today. So just to reassure you that if you are caught by both legal regimes, then you can have one data protection officer for both the UK and the EU GDPR. So that's really great news. If you do have establishments though in multiple countries, the DPO must be accessible from each of them. So that's normally okay just to have an email address, telephone numbers made available to data subjects as long as you're easily accessible to them, because the DPO is the main point of contact, isn't it, between data subjects and the data controller. Okay. I'm just going to finish each section really with some practical tips, because I appreciate this is quite a lot to get your head around. So my practical tips will really be, think about your documentation. So obviously the accountability principle under the GDPR requires you to demonstrate your compliance. It's not just enough to comply with GDPR, you have to be able to demonstrate it too. So this means that you will have got a lot of documentation already in place that might need to be updated to reflect the fact that the UK is no longer part of the EU. So, for example, privacy notices or privacy policies which explain to individuals how you process their personal data, they have to document international transfers, and we'll talk about international transfers next, but those might need to be updated depending on what they say at the moment and depending on what you do in practice at the end of the transition period to reflect what's going to happen going forward. You might as well have other documents such as data protection impact assessments that need to be updated because you might have done a DPIA on an international transfer on something that involved international transfers. My third point really is consider the scope of your processing, and this comes back to this whole point around data mapping, and this will be a common theme, I think, of today's presentation. It's really important to know the data you're using, what transfers you're making, whose personal data you're processing, where are they located, that kind of thing. Because until you have that information, it's really difficult to take it forward any further. So consider the scope of your processing. But just again to reassure you, the GDPR, the UK GDPR rule is not going to be fundamentally different from what you're complying with at the moment. So most things are not going to change. Data subject rights will still be the same. So people will still be able to make subject access requests. There'll still be an obligation to undertake data protection impact assessments in certain circumstances. You should still have staff policies and staff training in place. And for all intents and purposes, I don't think those are going to change fundamentally because the information security requirements, for example, are still going to be the same under the UK GDPR. There's just a few very specific points that we're dealing with today, but fundamentally things are not going to change too much at the end of the transition period. Okay. International data flows then. So one of the principles of the GDPR is to ensure that the personal data of people in the EU is still protected when it's transferred outside of the EU, or outside of the EEA, I should say. So the protection travels with the data. That's the point of the GDPR, and that's the point of the international transfer provisions in the GDPR. It's to ensure that people like us currently in the EU still get that protection when our personal data is transferred to Australia, to the United States, for example. Now, currently, the term restricted transfer is used to describe a transfer of personal data outside of the EU at the moment. Like I said, it's restricted to give us that protection. So there are certain things we need to think about, which we'll think about in the next slide, that put protections in place. Currently, a transfer to a country outside of the EU and the UK is a restricted transfer. However, after the transition period, for the purposes of the UK GDPR, any transfer outside the UK will be a restricted transfer. And so there might be transfers that are currently taking place with no problem at all, but you'll actually need to think about actually at the end of the transition period. Now, restricted transfers can be made lawful if there is a transfer mechanism in place. Now, these transfer mechanisms, some of them should be familiar, some of them may be less familiar. So at the end of the transition period, if data is transferred from the UK, it's compliant if one of these four things is in place. So if the data is transferred to the EEA, it remains compliant under the UK GDPR. This is because the UK government has confirmed that organisations can transfer personal data to the EEA. The UK government has essentially made a provisional adequacy finding of the EEA countries. So it's basically, they're deeming it safe to transfer personal data from UK people to the EEA. Unfortunately, so far, the UK itself hasn't received that same adequacy finding from the EU. So whilst data can go from the UK to the EU, it can't come back again without a safeguard in place. And we'll talk about those safeguards in a moment. The other situation where it's fine to transfer personal data outside the UK without taking any extra action is if the country has an adequacy decision already from the European Commission. So the European Commission has the power to deem a country's data protection laws adequate. So coming back to the point I was making a moment ago around the point of the GDPR being to protect personal data even if it's transferred abroad, what the Commission have done is that they've looked at the data protection laws of certain countries and they've deemed that those countries have an adequate level of data protection in place. I've put some examples on the slide there, but we'll go through those countries in a bit more detail in a moment. Now, if the country doesn't have an adequate decision and it's not part of the EEA, you'll need to think about whether either an exception applies under Article 49 or whether you can rely on an appropriate safeguard, such as standard contractual clauses. The appropriate safeguards are listed in Article 46 of the GDPR. But that is obviously at the moment subject to the Schrems II judgment, which we'll consider in a bit. Okay, so adequacy decisions. So the UK will continue at the end of the transition period to recognise existing EU adequacy decisions. And these have been given to the countries on the slide here. So you see there's quite a few countries, but there are some notable omissions such as Australia and the United States as well. Now, Canada's an interesting one because Canada's adequacy decision is only in relation to commercial organisations, so it's a partial adequacy finding. Now, there is some good news. It was agreed earlier in the year that Japan would have an adequacy decision as well. So we can add Japan to the list of countries where it's safe to transfer personal data. From the 1st of January 2021, the UK has the power as well to make its own adequacy decisions. So we might see in the course of 2021 that list of countries on the slide hopefully will start to grow, which will make data transfers throughout the world a lot easier. So I mentioned that there were some exceptions to the rule that you have to have this protection that follows the personal data. These exceptions under Article 49 include explicit consent. Now, explicit consent is quite a difficult one because you may remember that when GDPR came in, the standard of consent under the GDPR is quite a high standard. Consent has to be specific, freely given, informed. And explicit consent in relation to overseas transfers means that actually you need to tell the individual whose personal data you're applying to transfer about the risks that might be associated with the transfer. So it's not really a panacea, explicit consent. There are also exceptions in relation to contracts between data subjects and the controller, or if a contract is in the interest of data subject. So if the transfer is necessary for the purposes of that type of contract, that is also an exception. And then the others include establishment, exercise, and defence of legal claims, so if the transfer is necessary for that, and if the transfer is necessary for the vital interests of the data subject, where they can't give consent. So this would typically be around medical information that needs to be transferred abroad in an emergency. Now, you'll see that some of those have got asterisks next to them. The reason for that is because, unfortunately, public authorities, when exercising their public powers, are not allowed to rely on those exceptions. But actually, because they really are very much exceptions, you wouldn't be relying on those routinely anyway. So these very much are exceptions for one-off transfers rather than regular transfers of personal data. So we'll talk about appropriate safeguards now under Article 46. So one of the other mechanisms of compliantly transferring personal data outside the UK is if you put an appropriate safeguard in place. One of those kind of the key safeguards really are what are called standard contractual clauses. These are model clauses that have been drafted and approved by the European Commission. And these essentially mean that you put these clauses in a contract between the data exporter, so the sender of the data, and the data importer, the receiver of the data. And the idea behind standard contractual clauses is that that provides a contractual protection to the personal data of an equivalent standard. However, this is very much subject to the Schrems decision, which we'll talk about in a moment. I've put some other safeguards on the slide here as well, but I'm not going to go into those in detail at all. Binding corporate rules, I don't think will apply to many of the people who have signed up for this presentation, so I won't talk about those in detail. Codes of conduct and certification schemes are also listed as appropriate safeguards in the GDPR. Unfortunately, at the moment, we don't have any approved codes of conduct or certification schemes, but I know that both the Information Commissioner's Office and the European Data Protection Board are both working on approving codes of conduct and certification schemes. So hopefully over the next few years, we might see that being used as an appropriate safeguard as well. So standard contractual clauses then in a bit more detail. The UK government has confirmed that it intends to recognise the current European Union standard contractual clauses. So you can continue to use those after the end of the transition period. Now, those of you that are familiar with them will know that at the moment, at least, they're not perfect because they're quite limited in their scope. So, for example, they can only be used between controllers and controllers. And controllers and processors. So if you're a processor exporting personal data, you can't use them. Now, those terms there, I'll just explain briefly for a moment. So the controller is the organization or individual who is deciding the manner in which and the purpose for which the personal data is being used, and a processor acts on behalf of the controller under instructions from the controller, and a contract must be in place between a controller and a processor as well. Now, new standard contractual clauses were recently published by the European Commission, and they are currently subject to public consultation. And from the 1st of January, the UK can also put in place its own standard contractual clauses as well. I anticipate that any standard contractual clauses put in place by the UK will have the same broader scope as the new ones that were recently published by the European Commission. So the European Commission has realised that the current ones are not ideal because they can't be used by processors wanting to export personal data. So hopefully when we do get UK-specific standard contractual clauses, they too will provide mechanisms for the multiple types of transfers that do take place. Like I said, they're subject to consultation at the moment. I think it actually ends today. So the European Commission will hopefully be looking at the feedback it has received on those standard contractual clauses, and hopefully we'll get those new ones in place as soon as possible, because they are much better than the current ones for the reasons I've explained. Once the new standard contractual clauses come into force, once they're finalised, parties have 1 year to put them in place. So there's a kind of a 1 year grace period to update your contracts for the new standard contractual clauses. But like I said, there's going to be many organisations that really can't wait for these to come in, because if you're a processor who's exporting personal data at the moment, they'll be brilliant for you, because you can't currently rely on the current standard contractual clauses. So fingers crossed they won't take too long to finalise the new standard contractual clauses. Which brings us on to Schrems II. So Schrems II is the name given to the decision of the European Court of Justice, or well, it's commonly called the Court of Justice of the European Union now, in July this year. So Max Schrems, who is an Austrian privacy campaigner, had concerns about the fact that personal data from Facebook was being transferred to Facebook Inc. in the United States. And in the United States, the public authorities, so the FBI, the National Security Agency, have access to certain data because they have quite broad powers for national security and law enforcement reasons. So Schrems argued that by transferring data to the United States, Facebook were in breach of the GDPR because the relevant protections that I mentioned before weren't in place. So this concept of the protection traveling with the personal data was being put at risk by the fact that in the United States, the law enforcement agencies, etc., have access to this data, and there's not a lot that EU citizens can do about it. So this went all the way up to the Court of Justice of the European Union. They held that the Privacy Shield was no longer valid. Privacy Shield was the transfer mechanism that used to be enforced to allow transfers in certain circumstances between the EU and the US. Privacy Shield is now gone. Those of you who have been involved in data protection for a few years now will remember that back in 2014, in what we'll refer to now as Schrems I, Max Schrems essentially led to the safe harbor regime also being found invalid. And he's done the same now for Privacy Shield. So if you were relying on Privacy Shield for your transfers to the United States, you can no longer rely on that. Now, the somewhat good news was that the Court of Justice found that the standard contractual clauses were still valid, because there was a possibility that they were going to argue or find even that the standard contractual clauses were no longer valid. Fortunately, they did say they are still valid, but with quite a big caveat. The court found that when exporting personal data outside of the EEA, the exporter, with the help of the importer preferably, must check on a case-by-case basis if the appropriate safeguard chosen, so the SECs here, the question is, will they provide an essentially equivalent protection to that given under the GDPR? So essentially this transfer mechanism of the protection transferring with the personal data, the question is that still actually the case? If, for example, the FBI in the United States can access the data. So the court held that exporters must assess if the law or practice of the other country weakens the effectiveness of the safeguard. Because the standard contractual clauses obviously are contractual between the exporter and the importer, but they're contractual, so they don't bind third parties like law enforcement agencies. Now, if you find when you do this assessment that the appropriate safeguard you've chosen, for example, the standard contractual clauses, are not enough, you must implement supplementary measures. Now, unfortunately, the court didn't provide much detail at all on what it actually meant by supplementary measures. But the idea behind supplementary measures is that you'd have your appropriate safeguard, and then you'd put extra measures in place to essentially lead to a situation where the protection given to the personal data is that equivalent to GDPR protections. But this is much easier said than done, as we'll come to in a moment. Now, just to reassure you, the Schrems II decision does not affect transfers if you're relying on an adequacy decision. So you can keep transferring personal data to New Zealand, to Japan, to Jersey, to Guernsey, to Andorra, to Argentina, to Israel, those countries that have been given adequacy decision. You don't have to worry about those transfers at all, because the EU has already assessed the laws of those countries as being fine. Nor do you have to worry about Schrems II if you're relying on an exception, so explicit consent, for example, or necessary for a contract with the data subject. Those exceptions aren't subject to the Schrems II decision, but as we mentioned a moment ago, unfortunately, those exceptions are of limited application, partly because some of them can't be relied on by public authorities, but also because they very much are exceptions. So if you're carrying out regular transfers of personal data, they're not appropriate for those. So two key questions follow the Schrems II judgment: how to assess the laws in a non-EEA country, and what supplementary measures should be used if you find that the safeguard is not enough to protect the personal data. Now, I'm afraid there are no easy answers to this, but I'll do my best to talk you through the European Data Protection Board guidelines. So I should probably explain, first of all, who the European Data Protection Board are. So the European Data Protection Board consists of the regulators across the European Union. So the Information Commissioner's Office used to have a seat at the table of the European Data Protection Board, We obviously lost that seat at the table when we left the EU in January, though. But it's basically a meeting of all the regulators in the EU, and they produce guidelines, they advise the European Commission on data protection and that kind of thing. Now, they have created some recommendations on the supplementary measures that would be appropriate to put in place if you find that the supplementary measure is not adequate. I've helpfully broken it down into a number of steps for us. The first step actually alludes to what I was talking about a moment ago, which is know your transfers. It's really difficult from a data protection point of view to be compliant. You don't know what you're doing with personal data, whose personal data you've got, that kind of thing. So know your transfers. Second step is identify what transfer mechanism you're relying on. So, for example, the standard contractual clauses, or are you relying on BCRs if you have those in place if you're a group company? Third step is assess the effectiveness of the safeguards with the importer, preferably, because the importer is going to be obviously in the country whose laws you're assessing. So they should be in a better place than you possibly to make these assessments. And then the fourth step is adopt supplementary measures to ensure that you're protecting the personal data to an adequate level of protection. Now, there are three types of supplementary measures that the European Data Protection Board talks about. Contractual, so you could have, for example, a contractual obligation on the importer to essentially try and push back against, the FBI equivalent in the country if the FBI starts to ask for the information. So if they receive an order or a request for the personal data from a law enforcement agency, could you possibly have a contractual obligation on them to push back against it? I'm not sure how effective it would be, but that's one of the things that has been mooted by the Data Protection Board. The second one is organizational measures. So, for example, policies, transparency as well with the data subject might somehow mitigate the risks around this. But really, we're talking about technical measures, and that's what the European Data Protection Board were really focusing on. So is it possible, for example, to encrypt the data in such a way that the law enforcement or the public authorities in the importer country wouldn't be able to access the data? That's unlikely to be practical because your processor is going to need to have access to it too. So often when personal data is transferred, it can't be completely encrypted when it's in the importer's country. One technical measure that might work is what's called pseudonymization. Pseudonymization is where the personal data is not totally anonymized, but it's essentially changed in such a way that it's not possible to identify the individuals that the data is about without other information that's held separately. So you kind of need both sections of it to actually be able to work out who the information is about. So it goes some way to protecting, but again, this might not be hugely practical. What I really want to make clear about the European Data Protection Board guidelines is that they do set a very high standard for compliance, and arguably they're not practical. They are out for public consultation, so we might see some changes. Interestingly, the consultation period over these guidelines had to be extended because they were receiving such a lot of feedback, because a lot of small, medium-sized businesses were saying, look, how do we possibly assess the laws in another country? It's simply not possible for us to do this. So this has been quite a, dare I say, controversial set of guidelines from the European Data Protection Board. But remember that these are the regulators. They don't create the law. These guidelines are not actually legally binding. And obviously you were talking about Brexit today as well. So your question might be, well, we're leaving the EU. What's this got to do with us anymore? So Schrems II, the decision, the court decision, that will pass through into UK law when we leave, because we'll keep EU case law in place, at least for the time being. But the Information Commission's Office, the UK regulator, has been quite pragmatic over these guidelines from the European Data Protection Board. And remember, the ICO itself lost its seat at the table of the European Data Protection Board, so it wasn't able to influence the guidelines at all. So the ICO have put out what I thought was a really useful and pragmatic statement about how it will approach any enforcement action in relation to Schrems II. It says we continue to apply a risk-based and proportionate approach to our oversight of international transfers in accordance with our regulatory action policy. And I'm going to talk a little bit as well about the regulatory action policy from the ICO in a bit, because I think that's really important to put these guidelines and Schrems II into perspective, that actually in the grand scheme of things, whether the ICO would actually take any enforcement action against you, particularly if you're a small or medium-sized organisation or a public authority, is actually quite questionable. So the question then, I suppose, for you is, well, what are the risks of us not being fully compliant? And we'll talk about that in a moment. I should also say that we expect ICO guidance on this point in due course. And the ICO did a webinar themselves last week as well on Brexit and Schrems, which I thought was a very pragmatic webinar. They gave the impression, at least, of being very pragmatic on this area. They do understand the concerns that small and medium-sized organisations and public sector organisations have in relation to this, because the standard of compliance has been placed so high. So practical tips again then. I'll come back to mapping data flows, because as the European Data Protection Board said as well, it's really difficult to be able to comply with the law if you don't know what personal data you're holding, why you're using it, that kind of thing. Now, with these safeguards, think about whether you can actually mitigate the risks here. So even if you can't put safeguards in place that would prevent a public authority in another country from accessing the data, you might be able to actually mitigate the risks here. So for example, could you reduce the amount of data that you're sending abroad? Could you, for example, change the type of data as well? So special category data is obviously given a lot of extra protection under the GDPR. Special category data is very sensitive data. So it's things like health information, information about ethnic origin, information about religious views, trade union membership, biometric data, the high risk data. So if you are transferring special category data abroad at the moment, but maybe you don't need to, maybe it's time to think about mitigating your risks in this area by stopping to transfer that type of data. I'm not saying that's a requirement or anything like that. I'm just mooting some possible ways of potentially mitigating the risks in this area. Because I think if the data is of a lower risk, if it's kind of standard names, addresses, that kind of thing, and not particularly sensitive, that really does help in mitigating the risks here. My other advice would be prepared to act quickly. This is a fast moving area. So be prepared to act quickly once we do have ICO guidance. Be prepared to act quickly once we do have a final version of the European Data Protection Board guidelines, because even though they're not binding, they might be taken into account, for example, by the ICO. Now, with international data flows, in my experience of advising clients over the last few years on this, I do sometimes find that organisations actually sometimes struggle to work out when they are actually making international transfers. So, for example, if you allow staff to sign up to new apps, for example, for work reasons, or new online services, are your staff members trained to check and speak to the DPO or the data protection lead about this, so that you can check whether any international transfers are taking place? Because a lot of cloud storage providers, for example, do have servers based in the United States. So do train your staff and make sure you've got this culture that staff know to speak to you about these things. Because if you don't know these things are going on, then you, as the person responsible for managing data protection compliance, are in quite a difficult situation in doing your job. Have procedures in place as well for authorising contracts. So again, the staff members that do have the authority to authorise contracts should know enough about data protection to know when to speak to somebody who is an expert in data protection at your organisation. So that you can act quickly, I would also recommend making sure that things are stored centrally. So all the contracts with standard contractual clauses, for example, should be somewhere where they're easy to access. So when you do need to update them, it's not a laborious process of working out when you're relying on standard contractual clauses and when you're not. Kind of get organised now, I suppose, to allow yourselves to act quickly. And also the final point here comes back to this accountability principle under the GDPR, that you must be able to show your compliance. So document what you've done around the Schrems II decision. Document the considerations you're taking into account. Maybe think about doing a data protection impact assessment as well. anything that can show that you've thought about this, I think is really helpful in mitigating the risks in this area. And I'm going to end on a section about the latest from the ICO. And then really finally, thinking about kind of getting my crystal ball out and thinking about predictions for 2021. So the regulatory action policy that I mentioned a moment ago, I really would recommend familiarising yourselves with the ICO's regulatory action policy. This is the policy that essentially the ICO follows whenever it thinks about taking enforcement action. And remember that ICO enforcement action isn't just about those big fines that everybody got scared about. It's also about, their ability to issue enforcement notices requiring you to do things, information notices requiring you to provide them with information. The ICO can also issue reprimands as well, rather than fines, if they think you've done something that you shouldn't have done. But the important point really for this webinar, I think, in the context of Brexit, is that the ICO are at pains at the moment to show themselves as being a pragmatic and fair regulator. They're not heavy-handed, particularly on smaller organisations. They really are there to provide assistance with what they think you should be doing to comply with the law. So I put a quote at the very start of this slide from Elizabeth Denham, who's the Information Commissioner. She said that we will pursue failures under the law in a way that is transparent, consistent and proportionate. The ICO are consistently using the word proportionate at the moment to show that they do take into account a variety of factors when thinking about whether or not to take enforcement action. The ICO have said that they will focus on breaches involving highly sensitive information, which is why I was making the point a moment ago in relation to Schrems II and the safeguards, that have a think about whether you can mitigate the risks there by not exporting highly sensitive data like special category data. They'll also focus on data breaches which adversely affect large groups of individuals, and also ones that impact vulnerable individuals. So the ICO very much are focused on what is the harm caused by breaches. They will target their most significant powers at organisations who are suspected of repeated or willful misconduct. So, if you make a mistake once, the ICO might just kind of, advise you what to do next time. It's where organisations are repeatedly making the same mistakes and not trying to do better, or where they're willfully breaching data protection law for kind of their own personal gain, for their own commercial gain. And they'll also think about taking enforcement action where it serves as an important deterrent. So if there's a particular, a particular organisation which they think is very much leading the way in a particular area of data protection non-compliance, they'll focus on those organisations. This is why they tend to focus on the larger organisations rather than the smaller ones. So in relation to Schrems II, I do very much think that they will probably target, if they do target anyone, it's more likely to be the larger organisations, the Googles, the Microsofts, the Amazons, that they'll think about taking enforcement action against, rather than the smaller organisations, particularly when if you have a contract in place with Microsoft, there's not a huge amount you can do often to negotiate that contract, so you haven't got a huge amount of power. It's the larger organisations that have the power to change things. So that's why the ICO tend to focus on them. So let's think about some recent action as well from 2020 and what this might teach us about data protection law post the transition period going into 2021. So you'll have probably heard that British Airways and Marriott hotels were given some quite large fines a few months ago. Not nearly as large as first thought, so not nearly as large as the ones that the ICO initially proposed to give to BA and Marriott. But they were still very high. They were still kind of tens of millions. 20 million, I think, was given to BA. I'm mentioning cybersecurity as the high-risk area here because I want to put Brexit very much into perspective. And coming back to the point I was making at the beginning of this presentation, actually, most data protection law is not going to change post-transition period. And that means that information security, cybersecurity remains a high risk area where you really should be focusing your attention. I'm not saying that international transfers and that kind of thing aren't important and that you shouldn't be looking at them. But if we're thinking about taking a risk-based approach, it really is the data breaches that remain the high risk area. We know that cybersecurity has become more of an issue during the coronavirus pandemic. Phishing emails have become more prevalent as well. So my advice would be train your staff on security, because that really is the high risk area. Make sure your staff know how to recognize suspicious emails. Also make sure you can demonstrate your compliance around security. It was interesting that the ICO recently released their accountability framework, which is how you should be demonstrating your compliance. And if you do ever have a data breach, and I'm sure some of you may have had to complete the ICO's data breach form, you will see that it asks you on that form what training staff have had, what policies you have in place to having had prevented that breach taking place in the first place. So just don't forget the essentials of data protection when thinking about Brexit, because these things, they won't change. It's still going to be the high risk area. Other things that the ICO have been looking at recently, and I think they will certainly continue to look at post-transition period into 2021, is transparency. They recently published an audit of the political parties, particularly around how personal data is used during elections. Experian as well were given an enforcement notice requiring them to provide privacy notices to practically every adult in the UK, because it turns out that Experian were using information collected for credit reference purposes for direct marketing reasons, and the ICO took a very dim view of this. So we know that what's called invisible processing, which is processing personal data without telling the individual about it, is something the ICO takes very seriously. So make sure your privacy notices are updated for Brexit, but also make sure your privacy notices are generally up to date and that you're providing them when you should be as well. So don't forget the basics. Don't forget the data protection impact assessment, the accountability, the data subject rights, because these things are all still in the UK GDPR. So really, most of your compliance is not going to change too much in 2021. But on that note, what are our predictions for 2021? I think we'll see much more guidance from the ICO on international transfers, which will be absolutely welcome, particularly in light of the Schrems II decision. Will we get a final version of the direct marketing code? The consultation finished in March this year, so hopefully we'll see something from the ICO on direct marketing as well. Cookies as well are certainly something that's being thought about quite a lot by data protection lawyers at the moment, because there's been a few cases recently on cookie consent. Cookies, by the way, are the things that track you across the internet, which kind of allow targeted advertising and that kind of thing. And the ICO have also been looking into the ad tech sector, which is personalized adverts. I think we'll also start to see some approved codes of conduct and certification schemes, which I mentioned are another appropriate safeguard to use to transfer personal data. And then the question becomes, how much will the ICO start to depart from the European Data Protection Board guidelines? I think we will see it start to depart. The ICO is at pains, as I said, to make itself appear and to be a pragmatic regulator. And the European Data Protection Board tends to be, dare I say it, slightly less pragmatic and very much more data subject friendly. And the very final thing I wanted to mention is that we are starting to see data subjects make claims in the courts for distress caused by data breaches and that kind of thing. So this kind of echoes what I was saying a moment ago about information security remaining the high risk area. Well, thank you very much for your time this afternoon. That's been a bit of a whistle-stop tour. So I'll see if we have any questions now, but obviously feel free at any time to contact me. My email address and mobile numbers on that final slide.
Thanks, Claire. That's a really helpful and very practical talk on post-Brexit data protection. We have had some questions that have come in on the Q&A box, so thank you very much for those. If I just put them to you, Claire, so you don't have to try and read them while trying to answer them. The first one was an anonymous one, which is about establishments in the UK, that exemption for UK businesses. It's basically a question over what is sufficient to an amount to an establishment. I think you mentioned branch offices. The question here is having a few members of staff based in the EU enough? Is there a definition of establishment? Do you have to put their details on the website, that sort of thing? Is there any sort of guidance you can give on that?
Establishment, I'm afraid it's a tricky one. There's some guidance in recital, off the top of my head, I think it's recital 22 of the GDPR talks about establishments, and there's certainly more guidance on this in the extraterritorial scope guidelines from the European Data Protection Board. The phrase real and effective exercise of activities and stable arrangements, I think are the key words really that are used in recital 22. I'm afraid this is one where, to give you a definitive answer, I would need more information from you. But really, I'm afraid it's a bit more complex than just having an office. It is possible that having a few individuals could be sufficient, but it depends on what those individuals are doing, because the processing of personal data has to be in the context of their activities. Yes, so sorry, that's not a definitive answer for you, but I'd be happy to talk about it further offline.
So it's very fact specific.
Yeah, absolutely.
Great, thanks, Claire. I'm just going to skip the first question from Mark Pack and deal with the second one. I think this was in the context of when you're talking about countries where there is already an adequacy decision. So the question is, what happens after the 31st of December if there are new adequacy decisions from the EU, or there are rescissions in relation to the existing ones? What impact does that have in the UK?
That's a really interesting question. The honest answer is it's up to the UK government, I suppose, what happens there, because under the UK GDPR, it's the UK government who decides who has an adequacy decision or not. So at the moment, I think for pragmatic reasons, the UK government is saying it will respect the adequacy decisions already given. But one of the reasons why the UK had to come to a separate arrangement with Japan is that the Japanese adequacy decision from the EU was, I think, finalised after we'd left the EU. So the UK government really is going to have to take the lead on that one. So it's going to be a wait and see on that point, I'm afraid.
I have my own question in relation to adequacy decisions. So it's going to be a question of whether the UK gets an adequacy decision or not. Given that the UK is basically importing the EU GDPR, what are the chances of us not getting an adequacy decision?
Yeah,
could it be a political decision, or is it only going to be objective?
It's difficult to say, Nick, to be honest. So there have been concerns raised by the European courts about the surveillance that takes place by law enforcement organisations in the UK. So the whole issue around Schrems II was that law enforcement agencies in the US are granted quite a lot of access to personal data from Facebook, for example. But actually, there are people that say actually the UK is not that much better. But I completely take the point that, you know, we're complying with the GDPR. We were members of the EU when those things were also taking place. So yeah, part of me does think probably that the adequacy decision is part of a broader discussions that are going on at the moment, and dare I say maybe an element of quid pro quo during the negotiations. Okay,
so another wait and see on that one.
Yeah.
Right, okay, question from Victoria Tucker, which is almost the reverse of the one we just had from Mark Packham. If the UK creates new standard contractual clauses, will they be recognised by the EU Commission, or will it require a specific ruling or approval before that happens?
No, they'll be separate, I think. The UK standard contractual clauses will be under the UK GDPR. So I can't see them being recognised by the EU. I haven't heard anything, at least, to suggest that they would be recognised. So the UK standard contractual clauses would, I think, be to comply with the UK GDPR. But these things are all very much subject to change at the moment as the UK and the EU negotiate the relationship going forward, which unfortunately, you know, Boris's dinner last night with Ursula, I think the things are still ongoing, but my suspicion would be that the EU wouldn't recognise the UK ones because they'd be UK ones.
Great. A question from Elizabeth Dunford. Are UK-based controllers expected to sign standard contractual clauses with UK-based controller suppliers if we're sharing personal data of EU citizens, even though there's no actual international transfer?
No, it's only international transfers where, so the question is, and this is the importance of mapping the transfers, isn't it? That it's only when the personal data is leaving the UK that you need to think about. So coming back to the definition of restricted transfer, it's only when the data actually leaves the country.
Okay, and then finally, then just coming back to the first question from Mark Packham, which I think was in the context of when you're talking about practical tips, so it might be quite a sort of general one.
Yeah,
I think the question is, do you think it would be helpful to consider a review of data sharing agreements where EEA subjects or territories are concerned?
Yeah, I think so. I mean, I'm generally a big fan of reviewing data sharing agreements on a regular basis anyway, because in my experience of advising clients on these types of things, how personal data is used does gradually evolve, it gradually changes. So you should be reviewing these things anyway to make sure they're fit for purpose. So yeah, definitely worth having a look at those, I think.
Great. Well, thank you very much, Claire. You'll be glad to know that that is all the questions from the Q&A box. To the attendees who have stayed online for those questions, if you have any further questions that you want to follow up with, then please, by all means, do follow up by email, get in touch after this webinar, and we'll be happy to address any. And we'll obviously be sharing the slides and the webinar afterwards. Likewise, if you do have any sort of further thoughts as to topics that you might like us to cover in future webinars, or in fact, if there's any sort of in-house training that you might like us to come and do, then please, by all means, do get in touch. Other than that, all that is left is for me to say thank you, Claire, for a very helpful and, as I say, practical webinar on data protection post-Brexit. And also thank you to everyone who's attended, and hopefully we'll see you at the next one. So thank you, everyone.